Yes, Mr. Squires.
My Lords, my Lady, I think just before the short adjournment, I was dealing with a third possible way for the Secretary of State to put her case if it's accepted that placing a notice in a private file is not the giving of notice. What she would have to show is that Section 41 allows the Secretary of State to deprive somebody of their citizenship without giving of notice, as required by Section 45. And I was just about to deal with 41(1)(e). And maybe the court has also found this. One thing we looked at over the short adjournment was the specific amendment in 2018, so the 2018 British Nationality General Amendment Regulations. And they're the ones that added 10.4. And what they say in the preamble is...
So what are we... I'm sorry, you've lost me slightly. What are we talking about? 2014?
2018, sorry. Did
2018.
I get the wrong... the submission I was going to make is that we are concerned here with regulations made under 41(1)(e). That is the submission I'm about to make. And
you made that before lunch.
Sorry?
You made that one before lunch.
But what I did, and to make that good, we've now found the 2018 regulation, the power that amended. This was before Mr. Justice Chamberlain, which explains, as we'll see in a moment, why he reasoned the case as he did, we say. And what that makes clear is that those regulations, which included the 10.4 amendment, it says this in the preamble, and we'll provide these to the court. The Secretary of State makes these regulations in exercise of powers conferred by Section 44(1)(b), 44(1)(e), and
44, you're saying?
Sorry, 41(1)(b), 41(1)(e), and 41(3). And when one then looks at those amendments, one can see that Regulation 3 of those regulations, which is the one that amended 10.4, added 10.4, is the only one concerned with notice. The other two, or the other regulations, are ones made under 41(1)(b) and 41(3). We'll provide the entirety of the 2018 regulations, but they were amending other parts which were concerned with...
But when I looked online, that's not what it said at all.
Did my law look at the 2003 regulations or the 2018?
2018.
It was in the preamble. This is what unless we've got different...
Well, I'm looking at the 2018 regulations. I've got them online. And it says, I mean, I can open the whole instrument. The Secretary of State, oh no, you're right, when you actually look at the regulation. It's funny, the Secretary of State makes the following regulations in exercise of the powers confirmed by 41(1)(b) and E and 3.
Yes.
Quite right.
And the other regulations, when one follows them through, relate to the 41(1)(b) and 41(3) powers. They're to do with naturalisation and waivers and those sorts of matters. It is quite clear that what the Secretary of State certainly was purporting to do was to make the amendments to Regulation 10 specifically under 41(1)(e) of the statute.
So you say that the argument that Ms. Giovanetti put this morning, that this was in exercise of the generally for carrying into effect the purposes of the Act, is falsified by that.
Well, no, we do. We say this was made expressly under the power contained in 41(1)(e).
The giving of any notice required or authorised to be given to any person under the Act.
My Lord, yes, and that's why, in order to succeed in this third way of putting the case, if I've got the numbering right, she would have to show that regulations for the giving of any notice required or authorised to be given to any person under the Act also encompasses a power to remove the obligation to give notice. We say that simply can't be right on any reading of that statutory language.
Well, except for the point that I put to her. I mean, that notice is, in many cases, not giving notice.
we'll come to that, because our submission is, and certainly what the learned judge found, is said that he found no authority which had permitted placing a notice in a file to constitute the giving of notice. There may be some more difficult questions which I'll come to about something sent to a last known address but not received, etc. I will make some submissions on that. But what the Secretary of State has to show is that this permits not giving of notice at all, simply placing something.
But that sort of, I mean, that sort of begs the question, that, Mr. Squires. I mean, of course, you're right. That's what the judge held it meant. But I mean, that's what the judge held it had to be shown. But it slightly begs the question, putting it that way.
Well, no, I'll come back. So it's 41(1)(e), make regulations for the giving of any notice required to be given to any person under this Act, and here under Section 45. And our submission is that that cannot encompass a permission to remove citizenship without giving notice. So my submission is placing a notice on a file is not on any analysis the giving of notice. So we do adopt what the learned judge said below, that on no use of the English language can placing a notice on a file be the giving of notice of an internal file. I'll come on to the slightly more tricky questions, but that we say...
And is there no other statutory provision that allows notice to be given by putting on a file?
Well, one example of the regulations that permit that is the one under the 2015 Act, which we say...
And you say that's valid?
That is valid.
So
because
how can it be valid?
Because 13.2, in 13.2 of the statute, Parliament has specifically...
Well, it just says you can deem stuff. Why does that allow you to give notice by not giving notice?
Because you deem something else. You deem something else to be notice as notice, and we say that's
completely contrary. I mean, it's completely contrary. Your argument requires that that's not valid either.
My Lord, we say with respect, no, because what a deeming provision is, and again I will come on to this, is to say something. It is a statutory fiction in the sense that you do something which is not the giving of notice, but it is deemed to be the giving of notice. And in fact, if this was the giving of notice, you wouldn't need, we'll see when we look at 10.4 in a moment, it is expressly a deeming provision. It says, when you put this notice in the file, notice is deemed to be given.
Then if it works under Section 13, it works here.
But look, 13...
That's why you're driven. I mean, this is the hole in your argument, is that you're driven to say that 13's okay and 13's not okay, if you're right.
My Lord, 13.2 says, tab 7, the regulations may in particular make provision about case in which notice is to be deemed to have been given.
Yes.
That means notice is not given, but is deemed to have been given. That's what we say 13.2 means.
But why then doesn't notice being given include where notice is under a regulation deemed to be given?
Because 13.2 is in the primary legislation, so it expressly allows the Secretary of State to dispense with notice and do something else deemed to be notice, whereas Section 41(1)(e) says exactly the opposite.
I mean, it's the exactly the opposite point is what I balk at, because it's of course it's a very attractive point. It sounds great and sounds obviously correct, and every lawyer in the land would say, well, of course that's right. But when you then go and come to your argument about when it's in the primary legislation to deem, it is therefore permitted to do exactly the opposite of what Section 41 says you have to do, Section 45 says you have to do. That's when it breaks down.
Well, my Lord, our respectful submission is not. Our respectful submission is that is exactly what 13.2 is doing. Otherwise, it doesn't mean anything we say. Section 4 of the Counterterrorism CTSA says you have to give notice. Section 13.2 says Secretary of State may make provision about case in which notice is deemed to have been given. That can only mean you don't need a deeming provision if you've given notice.
Well, that's what Section 10.4 says.
Precisely, and that's not in primary. That is precisely it, Mother. That's precisely the criticism.
So it's a perfectly good mechanism. It's a perfectly good mechanism for giving notice, but only if it's in primary legislation, because it is so contrary to the wording of the primary provision.
Well, it's not a mechanism for giving notice. It's a mechanism for doing something instead of giving notice. That's what puts it in the file.
I mean, then it's a distinction without a difference, because sending it to the last known address where you know the person doesn't exist is also a mechanism for doing something that is not giving notice in order to give notice.
And that may or may not be permitted. We can have a look if one wants to get into the details whether that would be permitted. The answer is, again, we'll see what Alan says about that, because it's considered a similar issue. But we have our submission is 41(1)(e), which is the relevant provision, says may make regulations for the giving of any notice required or authorised to be given. And our submission is you cannot read that as dispensing with notice, whereas a deeming provision allows you to do precisely that, is you do not need to give notice, you can do something else and it will be deemed, and the regulations made under that section seek to do precisely that. But I'll come back to that, if I may. My final introductory point is that much of the Secretary of State's case on appeal and below relates to the practical difficulties that would be caused by Mr. Justice Chamberlain's interpretation of the legislation. And he recognised, this is paragraph 50 of his judgment, there are no doubt arguments in favour of amending the statutory scheme so as to permit the making of an order without giving notice, in a case where it's not reasonably possible to do so.
I mean, you're pushing it an open door. Obviously, if it's unlawful, it's unlawful. I mean, you know, the fact that it's practically difficult has got nothing to the point. The point that I'm putting to you is not that it's practically difficult, but that the legislature, in public law situations, would envisage that giving notice to somebody is a procedural step, which doesn't mean the same as it means in private law.
Well, no, what we'll see from the authorities in a moment, we'll see that ALAM is a public law authority which treats the meaning of giving notice in precisely the same way as, and relies on all the same authorities as in the public law context. So I'll come in a moment to what we say giving notice means. But we do say it is important when one is interpreting the statute to say, yes, there could be arguments for not having a notice requirement, but there are also obvious and strong policy arguments for why Parliament may have intended precisely what it said, which is you cannot give notice of something as fundamental as deprivation of citizenship. Sorry, you cannot deprive someone of their citizenship. You cannot do something as fundamental as permanently extinguish someone's citizenship without telling them. And that is particularly where there are other powers that the Secretary of State has to deal with people using their passports, people returning to the UK. The point is simply that one can see policy arguments both ways, both, well, there may be problems when it's not reasonably practical, and also policy arguments the other way. It says, no, citizenship is that fundamental that it cannot be removed without the person knowing. And what the judge said, which we respectfully endorse, is that the proper place for those arguments is in Parliament, which can amend the 1981 Act if it wishes to do so, and that is precisely what Parliament is currently considering. It is currently considering whether to impose...
Is that caused by this case?
I believe it is, my Lord, yes. Certainly the timing would appear to fit, but it's not, I don't know if it's...
And which bill? It's in a bill that is currently going through Parliament?
Yes, the Nationality and Borders Bill.
Oh, yes.
Currently, it includes a clause 9. We have the section in the bundle that the relevance of it is. And
yes, Nationality Borders.
Yes, and Parliament will precisely consider these policy questions. Should there be a rule that says you need to give notice, full stop, or should it be, well, if
how far has the bill got?
I think it's in committee stage.
It's in committee.
House of Commons committee, I think. Is there.
And your point is that in Parliament, the competing policy arguments will be considered.
Precisely. That is where the debate about what are the difficulties currently posed by.
What's the formulation used in the new bill? Is it exactly the same as section 13, or is it some
The
different?
current proposed, no, it's different. It's and again, this is
9, isn't it?
it is, yes.
It's express about removing the obligation to serve notice at all in certain
Page
circumstances.
29 of it.
Yes, it removes. It's to add 5A, page 30.
5A.
It's a completely different mechanism, isn't it?
It is.
No deeming here at all, just a disapplication.
It's simply a
of the obligation to
disapplication.
serve.
So again, Parliament is, and one can see this is the say it's not reasonably practicable, otherwise in the public interest. It simply disapplies if the Secretary of State considers that. That's the mechanism here. And 5.
And you say that if this goes through in this form, that works. That's our primary legislation says they can do the thing that they want to do.
Yes. Yes, and, but the only point about that is where this debate about does this cause difficulties for the Secretary of State ought to be resolved, because one can see there are arguments both ways. There are arguments that say, well, even if it does cause difficulties, removing someone's citizenship is so fundamental that you shouldn't do it, and you've got other mechanisms available to you, versus you can see the arguments that no doubt the government will deploy. But that is for
The
Parliament.
world is very different from 1981.
But yes, and as I say, all of that argument can be had out, but what we do say is that cannot change the meaning of section 45. Because Parliament has decided... Sorry.
I wanted to pick up something on section 41(1)(e), please, which is the enabling provision that you challenge. You say it doesn't go as far as Secretary of State says it goes. But it does plainly authorise an extent of deeming, doesn't it? Because we see, I think it was Regulation 10.6 as a deeming provision, and nobody says that the government wasn't entitled to have that as a deem. So you can have some deeming regulations on some aspects of your notice. So there will be some circumstances in which your recipient of the notice doesn't actually get notice, and that's all fine, isn't it, within the regulations as they've been amended?
I will come on to 10. Can I deal with that?
Sure.
Because I was certain I was going to deal with 10.5. Expecting my lady's absolutely right, and Mr. Justice Chamberlain dealt with the 10.5 provision in his judgment. We respectfully say correctly, and it is important to see that this.
Can I just tell you what my question is?
Yeah.
My question is this: if there are some sorts of deeming that are okay, inserted into the regulations in 2018 by Section 41, why do you draw the distinction with the 2015 Act and the provisions in that statute, which equally couldn't you say of those that some sorts of deeming are okay and other sorts aren't okay?
Can I show? But perhaps I'll deal with it. I'll deal with it now. If one sees how it was dealt with by Mr. Justice Chamberlain, it's paragraph 46. And it's the last, and I'll respectfully, this is the correct analysis, and I'll go back to 10.5. It's the bottom half there, he says that power, which is talking about section 41E.
Yeah, but 10.6 is not a rebuttable.
Well, Lord, it is. 10.5. It's 10.5 is a rebuttable.
10.5 is rebuttable. 10. What about 10.6?
That is giving notice to the representative.
Yeah, but the representative may not be relevant for one reason or another.
Isn't there a funny definition of the representative? It's anybody who appears to the Secretary of State to be the representative, so it may not even be actually the representative. They may know nothing about the individual.
And you've got a deeming provision which could effectively have the same effect.
Yes, I need to consider whether that, if you had someone who...
So where does this ultra vires stop? I mean, that's the problem I've got really with this, is that this is a whole regulation, a whole set of rules, which is intended, and Ms. Giovanetti's really her main point, is that this is a reasonable approach for the government to have taken by way of subordinate legislation to give effect to the Act. And do you say it's unreasonable, or do you just say it's procedurally done the wrong way? I mean, I think you're saying the latter.
No, I'm saying our submission is neither of those. It's a third one, which is that the 45 requirement is to give notice.
Well, I know you say
that. My Lord, and so we simply say it's outside the power.
It doesn't matter. You say the point I'm putting to you is irrelevant.
It doesn't matter if it's if the Secretary of State thinks this is a reasonable way.
It doesn't matter if it's reasonable at all.
It doesn't matter if the Secretary of State thinks this is a reasonable, proper balance to strike. That's for Parliament. Parliament has said you must give notice. And our submission is that, and again, there may be difficult areas, and this is precisely what Mr. Justice Chamberlain left open. There may be difficult questions about, and 10.6 may well fall within that.
But there's a distinction that all these other deemings, these deemings of 10.5 and 10.6, are attempts to give notice.
Precisely.
Whereas 10.4 isn't.
Yes. And that's what
so
he
said. It crosses
said.
a line. It sort of crosses the Rubicon.
Yeah,
beyond being a way of giving notice into, in reality, you would say, being the antithesis of giving notice.
Yes, something with no prospect. And that's the way the learned judge dealt with it below. He if you like, stopped short of saying, he said, strongly arguable that it must mean actually received. But he said, I don't need to go that far because on no analysis can this be fit within 41(1)(e), which is a provision for the notice required to be given under the Act. 10.5 is rebuttable, so that doesn't cause difficulties. 10.6, I appreciate one would need to look at it more carefully, maybe, and that may be where one would have an argument about it.
Doesn't that slightly dilute the absolutism of your submission under Section 40, subsection 5, which, as I've understood it, is that the Secretary of State is mandated by Parliament to give notice? Because there is obviously a middle area where the Secretary of State can make some regulations about how notice is to be given in difficult circumstances, if I can call it that, and they obviously have a power to do, don't they, some deeming in some circumstances, and we see examples in Subreg 5 and Subreg 6. But you say they're going too far if they get to the point where they adopt the antithesis.
Well, I'm going to make both submissions. I'm going to make the sort of the purist submission because we do say the words giving notice has been interpreted repeatedly in statutes. And it is clear, we say, that the meaning in both the private law context and in a public law context is a notice is not given to a person unless it's received. Now, you can have rebuttable presumptions of receipt, which the person can come along and say, well, yes, it was sent to my last known address, but the postman stole it, or something like that. And so on that analysis, what one cannot do is have a provision that removes the obligation to give notice. And this is what the learned judge below said. You can't have an irrebuttable presumption that notice has been given when it has not been. So to answer my lady's point, I will both make the easier submission, if you like, or easier on one level, because we say, look, on no analysis, that was what the learned judge said, can this be giving notice? But I do make the perhaps the more purist argument that, and we'll see that the authorities that have considered it is clear we say what giving notice means, and it requires receipt, and it's been repeatedly held, including relatively recently by the Supreme Court. And in that case, what you can't then do is have a deeming provision when a person has not been given notice that says they have. If Parliament says expressly, you must be given notice. Can I turn to the statutory, my submissions on the statutory provisions? A number of these have been trailed already, but it might help just to turn up. I did have some additional submissions on section 40. which you have tab 3, page 11. And you've seen the 42 is the first, is the deprivation order, and then section 45, and it may assist just to, apologies, maybe easier for you using paper copies, just a flick to see what Mr. Justice Chamberlain said about section 45, which is at paragraph 42 of his judgment. This wasn't a paragraph that the Secretary of State has taken issue with in writing or orally. And we respectfully endorse the learned judge's conclusions. And we do say this, and again, this is important when one is then interpreting any provision that removes an obligation to give notice or deems something as notice. One needs to start with what the notice provision is, which is section 45. And it is, we say, quite a striking provision. It's not a provision which one quite often sees to make notice after a decision's been taken. It is very deliberately notice before the decision has been taken. And it's not now an issue on appeal, that it is a condition precedent to make an order. You then have quite detailed requirements as to what must be given with the notice. Decision, reasons, and critically appeal rights. And as we say, as the learned judge obviously correctly noted, it doesn't say if reasonably practicable, doesn't say if possible. And what is striking about this provision, or perhaps the most striking feature, is that the entire purpose of having a two-stage process for the removal of citizenship is the giving of notice. Otherwise, there's no point otherwise. As the learned judge noted, once it had ceased to be suspensive, an appeal, the only purpose of having this elaborate two-stage process, decision, then order, is the requirement to give notice. Otherwise, it's not doing anything.
What is the effect of a decision? A simple decision has any effect at all?
It gives, you can appeal against it. It triggers an appeal right.
Nothing else flows?
No.
So it would have been possible for a scheme to be constructed with a suspension of citizenship pending appeal, but that's not the consequence of the legislation.
No, and it could have been a scheme where you make the decision and then make the decision and an order at the same time, and then give notice afterwards. Parliament clearly, and again, one of the, and this is why one needs to be careful about making, we respectfully say, and perhaps I'm guilty of it in part, of making very general submissions about what giving notice means. One is looking, it's the section 45 requirement that the regulations are seeking to bring into effect or to give effect to. And it is, we say, a striking notice provision, as I say. And what's important about it, Parliament must have thought notice was of particular importance, to have this entire scheme set up where the only purpose of it is prior notice.
Well, there was a slight divergence of view, or at least divergence of expressed view, as to whether notice was part of the purpose. As far as Regulation 41 is concerned.
Well, our submission is this. It is certainly critical to what Parliament must have intended to be a fair deprivation process, because it set up this entire elaborate scheme and it continued it after it ceased to have, that you ceased to be able to suspend the order. It must have done that because it was important to what is fair in this context. And again, we can see all of the different policy arguments as to why you would have this, not, if reasonably practical, not diluted in any way, given the importance of what's at stake.
These regulations introduced by the positive or negative procedure?
We can, I don't know off the top of my head, my lord, but I've turned around and I hope that'll. So that's the notice provision. 41(1)(e), you already have my submissions on, or 41(1), and in particular we say this is a 41(1)(e). And again, may help just to see what Mr. Justice Chamberlain said about this at paragraph 43. Again, this hasn't been expressly challenged by the Secretary of State. Though I assume she must disagree with the second and third sentence. He's dealing, we say, correctly with 41(1)(e), regulations for the giving of any notice required or authorised to be given to any person under this Act. On its face, that power authorises the making of regulations about how, not whether, notice is to be given, does not in any of you dispense with the requirement to give notice. We respectfully say that is correct. Again, one is reading this particular statute, is particularly 41(1)(e) with 45 to see what the powers. This is why, in answer to my Lord, the Master of the Rolls, we did say it is a question. It's not about reasonableness. It's about construing these powers. It's construing 45 with 41(1)(e) and saying, does it permit service of notice to file? But also, you then have the Regulation 10, tab 6, or the Regulation 10 as it's now, as it was brought in 2018. And you have 10.1, which is ways that you can actually give notice. And our submission will be, when we come and look at the authorities, that notice will be given if it's received. That's we say clear from the authorities. But certainly any of these methods are ways in which notice can be given and will be given if received. 10.4, you then have the deemed to be given when placed in the file.
Notice has to be received.
That's what the authorities say, what it means to give notice.
Well, that would be extraordinary in this context, wouldn't it? I mean, in the context of removing citizenship from people likely to be placed in war zones or places where the first-class post doesn't really deliver things to their door.
It can be received, this is the UKI Kingsway point, you can have notice received indirectly, you can send it to someone and it is passed on. That's what the Kingsway case was about. It is still received even if someone else passes it on to.
Right, so the service is not effective until you've inquired of the representative, say, or the parents, or somebody else you're allowed to serve, and made sure they've passed it on. So how does that work?
Well, the question is, as we'll see, this is my perhaps but the purest submission that my lady was put to me, is that is what the authorities say giving notice means.
Is your point that unqualified, just for look, if 10.1 wasn't qualified, it would have to be received for any of those process, for any of the service to the notice to have been given.
Yes, it is.
But it is qualified, for example, by 10.5, which provides that where it's sent by fax, it's deemed to have been given when it is sent. So, so are you therefore arguing that without that deeming, it wouldn't have been given until it's received?
Well, it's 10.5 is unless the contrary is proven. So it's presumed that if you send it to someone, they've got it. But if they haven't, if they can come along and prove that they never received it, I mean, that's what the rating case is about. It's what we'll see some of the immigration cases are about. If someone is able to come along, you presume that you've got it. If you put
are you saying that the 10.5 is built on the assumption that without it, it would have to be positively received for notice to be given? Is that what you're saying?
Well, yes, and what 10.5 does is create a rebuttable presumption that if you put it in the post, you've got it. You would then have to come along and prove that you didn't receive it. As I say, we'll see this is, and in response to my Lord's question about, well, all the difficulties of people in war zones, etc., that's precisely the balance, or precisely the issues on both sides of the line that Parliament will need to consider. Yes, correct, there may be difficulties in giving notice here, but also correct, you are permanently extinguishing people's citizenship. And so for something that fundamental, Parliament was entitled and did expressly require notice before you could make the order. That we say 1045 is clear. And so, correct, there are more difficulties with notice than, for example, decisions about rate, whether a building goes into rateable occupation. But conversely, this is a decision it's about the most fundamental decision the executive can make about someone, to permanently strip them of their citizenship. We say Parliament has, as currently formulated, required the giving of notice before that can happen. Someone should not be stripped of find they are stripped of their citizenship without being told. That is what Parliament has said. Now, there may be arguments both ways on it, but that is what we say Parliament is currently legislating. I'm told it's a negative resolution procedure in answer to my Lord's question.
So it doesn't actually get voted on unless somebody moves it.
Correct, yes. My Lord's Way, turning next, I was to make some brief submissions about the principles of statutory construction that we say apply here. The court will see in the judgment below, paragraph 20 to 22 sets out the submissions we made below. And I won't take you to it because it really would only be to show you this paragraph, and the rest of the case deals with different points. But 20C, you'll see the quote from Williams and the Central Bank of Nigeria. And we do rely on that. I appreciate that. What that takes us back to is what is the meaning of the words used. But the key, we do say the last sentence, quoting from Lord Reed in the Black Clawson case, is we often say that we're looking for the intention of Parliament, but that is not quite accurate. We're seeking the meanings of the words which Parliament used. And this is simply a warning or a stress of the importance of the courts, not focusing in some wide way on context and mischief, but the role is to say, what is the meaning of the words used? We also refer there, you'll see, to the drafting error context. I understand there was some suggestion that was being raised below in terms of things falling out of legislation, but it doesn't appear to be raised now, so I don't need to take you, I think, to the INCO case. But I would like to take the court briefly to cases about consequences or consequential matters. In this sense, that much of the case before Mr. Justice Chamberlain, and again before this court, is of the consequences that would arise if citizenship could not be removed where notice is not reasonably practicable. It appears repeated. I won't take the court to the references, but it appeared repeatedly in the defence below, and again it appears in the skeleton argument now on appeal. And as I say, I'll come briefly, and I've already touched on it, to the policy arguments, and I can very well see policy arguments both ways as to whether citizenship should be removed if notice is not reasonably practicable. But our submission is it's important to see where the court, in what circumstances the court considers those kind of practical consequences, or in which circumstances is it legitimate for the Secretary of State to say, well, look at the concerns that may arise if the statute is interpreted in this way. And what is clear, we say from the authorities, that only arrives if you've got some sort of ambiguity in the language in the statute. And otherwise, if there are concerns about the impact which a particular interpretation of legislation has, the answer is that is for Parliament to resolve.
Well, that's certainly the position with contractual interpretation following rainy sky.
Well, our submission is that it is also the case in relation to statutory interpretation, including, as we'll see, statutes that are not a million miles away from the kind we have here. Can I just take my lords and my lady just to highlight the key parts of the authorities, because we do say it's important to this extent to go back to first principles, if I can put it that way, which is, and I know the court will have this very much in mind, the appropriate role as between the court and the legislature when there is some concerns about practical effects of particular interpretations of legislation and whose role it is, in effect, to correct or to deal with those practical concerns. And the first case is Stock and Frank Jones, which you have tab 12. And the particular legislation, I don't need to go through it in any detail, but it's, again, entirely different context. This is the Trade Union Labour Relations Act 1974. And what it provided was that it wasn't unfair to dismiss people because they were on strike, so long as the employer didn't dismiss all the employers who were on strike. And the issue of statutory construction was, in this particular case, the employer, a whole group of employees were on strike, 2 employees went back to work, and then the remaining strikers were dismissed. And the question was, of statutory construction was that a potentially unfair dismissal? And the argument of the employer, which succeeded before the Industrial Tribunal but then failed up to the House of Lords as well, that would lead to obvious practical difficulties if that was the correct interpretation. And that argument was rejected by all the members of the House of Lords. And just to highlight the key passages, first in Viscount Dilhorne's speech, you have at page 51 of the electronic bundle 235 D to E. You see, it says the much weight, just to read that, much weight sought to be placed on the anomalies that suggests that you can actually see arguments both ways. But existence of anomalies, if they exist, cannot limit the meaning attached to the clear language in a statute. So we'll come back to that in relation to section 45. Then Lord Simon's speech, and perhaps if the court can just glance down from 235G, so it's starting in his argument based on the alleged anomaly, counsel of the appellants. Rather attractively named Lord Wensleydale's Golden Rule, and then down to that's the end of G on the next page, 236G.
Yeah.
And it's particularly the last full paragraph of what, when one looks at what are said to be unwanted consequences, it only arises where you have 2 possible meanings of a statutory provision, and you can say, well, Parliament cannot have intended these particular consequences. What you can't do, says Lord Simon, is say Parliament has said X, but it obviously meant Y. So we will take Y as the effect of the statute. Nor is it declaring Parliament has said X, having situation A in mind, but if it had thought of B, it would have done something else. And we do say, and we'll come back to section 45 in particular, there is no ambiguity as to what is required. We say by section 45.
Are you saying that the Secretary of State is inviting us to do, as it were, what Lord Simon says we shouldn't do in the second of those two examples, nor it is declaring? Parliament has said B having A in mind, but if it had B in mind, is that what
yes, or the first one is that Parliament must have meant to include a reasonably practicable exception to the giving of notice.
Well, it's not the way she's put it.
It's not, but my submission is that must be the effect, because otherwise you are depriving someone of their citizenship when they have not been given notice.
Well, I'm not sure you're really addressing the issue here. I mean, the real issue is the giving of notice in the context of this legislation is not always the giving of notice as understood in a binary form in cases on property and rent, that kind of thing, possession. And the question is whether you can, in the context of citizenship and national security and so on, all of which this is the context, give notice in a variety of deemed ways to achieve the giving of notice, properly understood. Now, you say notice is a binary concept, that's what the judge said, this is the antithesis of giving notice. I get all that. I mean, I completely understand the argument, it's very neat. But it does give rise to the problem that actually everybody always knew that in many cases when you give notice under a statute, the person has not got that notice in fact.
Well, in answer to that, I say the stark binary form is perhaps, if I can say, the purer way of looking at legislation. In fact, the judge said he didn't need to decide.
Well, I mean, but he did decide, because he said this is so clear because it is the antithesis of giving notice. But that assumes that the words giving notice are understood not in every other statute to include doing a process which actually does not succeed in bringing the matter to the attention of the recipient. That's the problem with the construction the judge adopted. I mean, it's neat, it's persuasive, it's everything. I mean, Mr. Squires, you're pushing at open doors as far as all that is concerned. But it is actually, in this situation, not quite as easy as the judge said, or not to me anyway. I mean, I find it difficult.
Yeah, no, it may be more difficult, but I suppose what the judge's easy answer, if I can put it that way, as opposed to the more complicated answer, was whatever giving notice may mean, it cannot mean
not giving notice.
Not giving. It cannot mean putting something.
My point is,
yes.
it can.
Yeah. Well, my lord, what it can mean, we'll see. He says this. Could it, in some circumstances, mean taking reasonable steps to give notice? And what he
or put what Ms. Genovese says, putting in place a fair procedure to give notice where you can.
The difficulty of all of that, and this is why I do come back to why it is a question of statutory wording, is you would still then need to interpret Section 40. Section 45 says,
must give notice.
Must give notice.
You have to interpret that as meaning putting in place a fair statutory procedure that allows you to give notice where you can, which is not quite what it says.
And thereby remove citizenship by doing something which, on no analysis, and that's, and I see, that is ultimately the key to the learned judges below's decision, is doing something that on no analysis, on ordinary English language, could be the giving of notice.
I mean, what I find difficulty with Mr. Squires is really not that argument is not a beautiful one and a lovely one for lawyers, but and therefore, one could simply say, well, that's right and that's the end of the case, but that when you delve down into deeming and other situations, that is exactly the same. If you're deeming something that is not giving notice, therefore other statutes acknowledge that notice doesn't always mean notice, and that notice is a process, and of course that's contrary to the House of Lords authorities in private law, and you say in Alam, which I haven't looked at yet.
Well, yes, but our submission will be, and I'll come back to the statutory point, is that what Mr. Justice Chamberlain said, which we respectfully say is correct in relation to my Lord's concern about other statutory schemes, is what he said is no authority was cited to him, and we're not aware of any, which has said placing a notice in a file can be the giving of notice. And
is there no other regime that has that process?
It does, my Lord, but no court has ever considered, has ever found that that constitutes the giving of notice.
When did the placing of notes in a file first start, as it were? When's the first piece of legislation?
That I don't.
I mean, is it modern? Is the point I'm making, or is it of any antiquity?
So I've turned around, not expecting an immediate answer.
You turned around, but your poor old junior is looking.
I know, he's looking on. She's online, so she might better. The answer is we don't know. We don't know. There certainly are other statutes, and there may be questions about the vires of other. I don't think this issue hasn't been considered.
Are you saying there is no statute? We're not aware of any statutory regime which says what precisely?
No, there's no. We're not aware of any. What the Justice Chamberlain, he's not aware of any case, any authority. There are statutory regimes, and we'll have a look at what Alam says. Says to some any statute. Maybe I should get the quote correctly from, in fairness to the judge. It's. It's paragraph 48.
The middle sentence?
Yes.
Second sentence?
Yes. And that's as far as we're aware, and that remains the position. And that is ultimately the construction exercise the court below is engaged in, and this court is engaged in, is.
But then he says Alam is not such a case, even though, because the enabling power is different.
Yeah, we'll look at Alam in a second. The main Alam is another, or the statutory regime considered in Alam was another one that had notice to file. But what he says is Alam, that wasn't the issue in Alam. The Court of Appeal simply didn't consider.
It wasn't. I mean, it just was never discussed. Was it?
Yes, and that was the point he's making at 2 and 3. There may also be a question of statutory construction about the 71 Act, if this issue was ever to arise, because it is certainly worded differently. We're concerned with this statute, but it's 2 and 3 that are the key. It simply wasn't considered in Alam because it wasn't a notice to file case. So the position is that it's simply on the authorities. There is no authority, and we'll look at the authorities because there's a whole range of authorities that have considered what giving notice means. And we do say it is both in the private and the public law context. They have given it the same meaning, which is what we will rely on. My Lord, but finally, my Lord, finally on this case, and this is how or where this issue should be resolved, is what Lord Simon then said. He then gives a list starting just below H, essential to the proper judicial function in the Constitution to bear in mind. And it is particularly 7 and 8.
And Factuosity.
Yes, I did. It means twisting, some overly twisting. I think I did look it up. Full of windings and intricate turnings. And it's particularly the last.
I love 4.
Yes, I did have to look that up as well about the difference. And that again is why we drew attention to what Parliament is currently doing, because you can have that debate about should you have the reasonable, practicable suspension of the requirement to give notice, or is citizenship deprivation too important? That is, we say, for Parliament, not. And our respectful submission will be interpreting whatever the difficulties, and I'll come to the moment about where one has things sent or things sent to representatives, etc. We do say our submission that it would be judicial contortion to get to a stage where putting something in a file, which you know a person can't see, is the giving of notice. That's the, I suppose that's the core of our submission and the core of the finding below. And that's why we do say that is then it is better for Parliament. And when we do say it is particular, it's noted at the end of the paragraph, dealing with apparently hard case with the result that ordinary citizens and their advisors hardly know where they stand. And we do say these are general, it is a general phrase or general requirement to give notice. And of course, you're interpreting the particular context of this statute. But it is, we say, important, or it is, perhaps more than important, it is that our respect, which is the court's role, not to interpret giving of notice in a way that simply does bear no relationship to how it would be understood by anyone speaking English, which is the language that rather colourfully Mr. Justice Chamberlain used. Secondly on this, and again I can deal with it briefly, but it's a similar point, but in a context significantly closer to what really is the AA case, which you have at tab 17. And this is about Immigration Act 1971, Schedule 2, paragraph 16, as it then was, which concerned the detention of unaccompanied children. And what happened here is that the claimant was detained for approximately a week, and during that time, it was reasonably believed he was an adult, but in fact, it was accepted he was age 16 or 17. The question was, should you interpret the legislation relating to the detention of unaccompanied children as including or as allowing the Secretary of State to detain someone who she reasonably believed was a child, but in fact wasn't? And the reason again, we're very brief on this case, but the reason I've taken the court to it is one of the arguments made by the Secretary of State is this has all sorts of practical difficulties for us. If we reasonably believe someone is a child, what are we then supposed to do in terms of detaining them? The court holds that is not a matter for the court, in effect. And you see the conclusion is Lord Justice Davies, if I think at some point he said, regretfully, at some point he had to reach this conclusion, but paragraph 45 deals with the evidence of the practical problems. And it's 45E, and I appreciate this takes the court back to what is the core question, is submissions about consequences, practical effects, fall foul, in my opinion, with explicit wording of the statutory provisions. And he goes on at 47 towards the end of the page. Elementary intention upon is ultimately derived from the statutory language it actually used. If the result which I reach in this case is unwelcome to the present government, then its remedy is to amend the statutory provision. It is not, however, a proper exercise of the judicial function to achieve such amendment by distorting the statutory language under the guise of purported process of statutory interpretation. Can I then come to our submissions? I know I've made a number of these have, of course, already been trailed, but the primary submission, this goes to the, I say, the two ways in which one can reach the conclusion that Mr. Justice Chamberlain did, the sort of, and we'll come on to the sort of, I say, the purer one about what giving notice means, but the way in which he interpreted the legislation, you'll see paragraph 41 of the judgment sets out the approach one takes to statutory interpretation. I don't think any of that is controversial. Certainly, the issue has not been taken with it, and where the words can bear more than one meaning, it's legitimate to take into account legislative history, context, and purpose. But in the end, the words are the hard limit. Paragraph 42 we've seen, and paragraph 43 we have seen when he interprets 45 and 41 1e. And our submission is, when one is interpreting 41 1e, one has to interpret it with section 45. One needs to interpret the two together. It won't do in our respectful submission to say, well, section 41 1e is very broadly drafted, because 41 1e allows the state to make regulations for the giving of any notice required to be given to any person under section 45. So you need to first decide what is required to be given under section 45.
Is notice required under any other provision in the Act?
I've turned around again, I don't know off the top of my head what I've done.
Well, surely it would be important to know that for that submission.
Well, for these purposes, and we'll have a look at whether there are other notice provisions, this is a provision for the section 45 notice.
Is special provision?
Yes, regulation 10 deals only with section 40 brackets 5 notice. So therefore, this is purporting to make provision for the giving of notice required to be given under section 40 brackets 5. Regulation 10 is only concerned with that. So that's what it's purporting to do. So therefore, we say one has to start with what is required under section 45.
Well, is that right? Because section 45 is in the part of the Act called miscellaneous and supplementary, which seems to deal with all the other parts of the Act, the British overseas citizenship, British subjects, etc. And it's under the heading, oh, I see, you say 40 subsection 5 only deals with
deprivation. It's actually it's regulation 10 is dealing with the notice required under section 45.
Yes, but 41, which provides for the making of regulations, applies to the whole Act.
Oh no, absolutely, my lord. But the one we're concerned with, what regulation 10 is purporting to do, is to make regulations for the giving of notice required by section 40 brackets 5. Regulation 10 only applies to 40 brackets 5. It makes that clear 10.1, where it's supposed to make an order under section 40. The notice required by section 45 of the Act is to be given by, etc. So that's why we do say one is asking under 41.1e 41(1)(e) says must give notice, which I read it. This is making provision for the giving of any notice required to be given to any person under, and here Regulation 10 is under 40 brackets 5. That's what it's purporting to do. And so the question, so that's why we do say the starting point is it is seeking to make regulations for the giving of notice required to be given. It permits Regulation 10 for placing the notice in a file where it's not under the circumstances set out there. And our submission is that the complete answer, or we'll certainly adopt what is said by Mr. Justice Chamberlain, paragraph 49, and that's, I'll come back to the more binary way of looking at it. That's not the way in which the learned judge reached the conclusion. The conclusion was simply, this is not the giving of notice. This cannot be the giving of notice required under section 40 brackets 5. You interpret those words, give a notice, and then reaches the conclusion that he does. And then 51, for these reasons, he concludes, did not give the power to make regulations that treat notice as having been given when it has not been given to that person, but instead simply been placed in a Home Office file. So it's interpreting the words giving notice and asking, are they capable of including placing notice in a file? Our respectful submission, I don't think I can do better than as is set out in the first two sentences of paragraph 49. And as the judge says, that is still the case under any ordinary understanding of the language, even if it's not reasonably practicable to give notice. Our submission is one is concerned with that bit of statutory construction. And our submission is that the fact that it is not reasonably practicable to give notice cannot mean by putting a notice in a file you have thereby given notice, because that is what the interpretation would have to be. The Secretary has to say, well, it's not reasonably practical to give notice, therefore I put the notice in a file. Or it's not practical to give notice, I put the notice in a file, I have therefore satisfied section 40 brackets 5. We say on no reading of the statutory language can that be correct, in which case it must follow that 41(1), that the 10(4) is ultra vires 41(1)(e). As I say, whether that's a desirable outcome or not should be a matter for Parliament, we say, rather than for the courts, to give a reading of give written notice, which on no, we say on no understanding of the English language, can it encompass. Now, I think it was put to me, or there has been a suggestion about, is there a sort of more purist way of looking at legislation? Because what Mr. Justice did not say is that you can never have deeming provisions in the legislation. He simply said this can't be the giving of written notice. He dealt with the more general question earlier on in his judgment. At 44 to 45, he dealt with other statutes. Oh, sorry, other cases, other authorities that have considered. And I'll come back to what's said about the CTSA briefly, because my learned friend took you to that. But he then said, sixth, since section 45 doesn't specify particular methods, which if used result in notice being deemed, given and received, and section 41E does not authorise the making of regulations having that effect, it's strongly arguable, he said, that giving notice bears the same meaning as the provision in Sun Alliance. So that's as far as he goes in terms of a sort of absolutist position or a clear divide position. He says it's at least strongly arguable that notice means the same thing as it does in Sun Alliance in the UK, i.e. you have to cause the notice to be received, though not necessarily read or understood. He then goes on at 7th, to say, well, look, there's another alternative argument, which is giving notice not always require notice to be received. On this argument, regulations under section 41 could do more than just create a rebuttable presumption. They could conclusively deem notice to be given when sent to the affected person's last known address. But, 8th, it's not necessary for me to decide whether this argument is correct, because Regulation 10.4 does not require any step that is even capable of bringing notice to the affected person's attention. But as we deal with this in our skeleton argument at 35, 35 to 37, and our first submission is we would respectfully invite the court to take the same approach as Mr. Justice Chamberlain did, which is not necessary to reach a final decision as to whether giving notice always requires notice to be received, or whether in some cases it may be sufficient to take reasonable steps. And that's for the reason the learned judge gave, simply on no analysis.
Well, I mean, the argument he doesn't really deal with there, that gets close to dealing with, is that it's not actually giving notice is a broader concept than just giving a notice that is received by the person in question. But in the context of removing citizenship, it's a framework of processes that may, in some cases, that are designed to try, but not necessarily to succeed, in getting the action to the attention of the recipient. So I say designed, but may not have that effect in some cases, and the whole process applies in a patchwork which is itself reasonable, as established by other legislation.
Well, what he did deal with, we say, which is the fundamental question, is can placing notice in a file be the giving of notice? So that was his starting point, or in fact, in some ways, his finishing point on that.
It was really his finishing point.
First issue.
It cannot be, because notice means notice. But if notice means a whole raft of things that actually happen in real life, then that could be wrong.
Well, I mean, I say, our respect for it is not wrong when one is considering placing something in a file in the Home Office. However, whichever route one has got there, one still has to go back to section 40(5) and say, you must not deprive someone of citizenship, or sorry, you must, before depriving someone of citizenship, give them written notice of X, Y, and Z. And our submission is there is no reading of that provision that can say, if you think it is not practicable to give notice, you can simply put a notice in a file. That is, we do endorse that submission, and we do say the court does not need to go further than that. But if one does go further than that, or if one then looks at the strongly arguable point, our submission is that is correct, and that our submission is that certainly insofar as authorities have considered the matter, there is no authority that has said giving notice can be, or one can give notice, if that is what's required by primary legislation, without the notice being received. If the primary legislation says, the primary legislation can say, give notice, and by giving notice we mean putting it in the first class post.
Does the reference to give the person written notice help you?
Yes, in the sense that Parliament has obviously thought it's important to include particular things in writing in the notice.
Well, I'm thinking of, you might say, you could give notice in the general sense I've been putting to you for some time now, to a person, even by putting a notice in the drawer, if that was all part of the patchwork quilt and led by the circumstances of removing citizenship in war zones, etc. But you could hardly say that was given a person written notice, which has the connotation of a physical thing.
But we would, in a sense, and it's also, it perhaps goes back to my earlier submission about the evident importance that Parliament has placed on written notice in this context. I say it's not just notice, it's written notice, it's particular things that...
Yes, particular component parts.
Particular component part, and on the face of it, you cannot make the order without having given the written notice. So all of that, but also I would certainly accept that observation and say that adds into the importance of what Parliament was evidently doing here, if one simply interprets what it has done. But our submission is that certainly from the authorities we have before us, there isn't any authority that has said a statute requires giving written notice is satisfied unless the notice is received. The statute itself can clearly make provision which says if you put something in the post, you have given notice, and that is a form of deeming provision. The statute can certainly say that, but there is no authority, certainly that either party has been able to find, in which it is said a provision to give written notice as such can mean anything other than giving a notice which is received. And that is across a range of different, that is, authorities that consider this across a range of different statutory schemes. So if the court concludes that it does need to go further than Mr. Justice Chamberlain and grapple with this question, not just what he did, I suppose, was in the negative to say this cannot be given written notice. If the court concludes no, it's necessary to grapple what does give written notice means, we say it is clear from the authorities that a requirement to give written notice requires that notice to be received. If it's
Where does that leave the regulations which allow for deeming notice to be deemed as given if it's been sent? We're looking at 10.5.
10.5 is not a problem because it is deemed to have been given unless the contrary is proved. So what that does is it shifts where the burden is, the burden of proof of showing you haven't received it. So if you put it in the post, I think this was the one dealt with by, is the second half of paragraph 46 of Mr. Justice Chamberlain's judgment, which is if you say you can have a provision that says if it is put in the first class post, it is deemed to have been given, sent and received however many days later. But if you can come along and say the postman stole it, notice is then, and you can prove non-receipt. So 10.5 is not a problem in this regard. I accept 10.6. I do need to look at it more carefully, maybe, and there may be an argument about it. That hasn't been considered, but certainly 10.5, you can allocate the burden of proving you haven't received something. And again, Mr. Justice Chamberlain says, look, that is a sensible way of getting legal certainty. But it doesn't allow, it's the irrebuttable presumption that is the problem. If you can come along and prove you didn't receive it, can you still say, well, sorry, you've been given notice? And our submission is that the authorities make clear, all the authorities that the party may be able to find on giving notice, and I say they do come from a range of different private and public law areas, all say it means receipt. It requires receipt in order for notice to be given. And our submission is Parliament can be taken, when it used the phrase giving notice, to be using the meaning that the courts have repeatedly said those words have. And our submission is also, and I'll come on to the authority in a moment, but our submission is also, that does fit the ordinary language. If you say there is an obligation, person A must give person B written notice of something, person A sends it in the post, and the postman steals it. Our submission is on ordinary language. Person B has not been given written notice. They did not receive that notice. Doesn't mean they have to have read it. We'll come on to this in a moment. But if they haven't received it, they have not been given notice. So that's the ordinary language. But we also say that is clear on a consistent line of authorities in a range of different areas. And we've seen, my learned friend took you to the UKI Kingsway. It's about buildings becoming rateable. There's also other authorities under Landlord and Tenant Act. And there's also ALAM, which is maybe a helpful place to go to because it summarises all of the authorities or sets them all out and applies them in a context, a much closer context than the present one, which is a public law immigration context. You have ALAM at tab 20. And this was about a power under section. If you look at paragraph 4, you'll see the notice provision there. So it's a differently worded one. This is back to Mr. Justice Chamberlain's one of his points when he looked at ALAM. Section 4. Curtailing leave shall be excised by notice in writing given to the person. And it is correct that the 2000 order made in relation to this provision does purport to allow service of notice to file. We've dealt with that in the skeleton. It's simply not an issue that was considered. The vires or otherwise of that wasn't considered by the Court of Appeal, because what happened here was that the notice was sent to both individuals. You can see the facts from paragraph 43 in relation to Mr. Alam. It's sent, in his case, 45 to the place where he accepted he was living. Mr. Rana, it was sent, I think, to his address as well, in fact signed for by someone with the name of Rana. So the issue in this case was what happens if notice is sent, but then the person claims not to have read it or claims not to have seen it. And the Court of Appeal, paragraph 22, this is why it's helpful to look at this authority, it sets out all of the relevant authorities. So if the court can glance down upon it, it's quite a long passage, but 22 to 31. This is all of the various authorities that have
So which paragraphs?
22 to 31.
Thank you.
Yeah.
But also, we say that the key passages there, and this goes to the various relevant authorities, it's the reliance on the anaphorieva and what's the particular place on Lord Stane in relation to the European, also the European law approach requires the person affected must have the opportunity to make themselves acquainted with the decision. That's what it means to give someone notice. And then stresses the importance of the constitutional principle. We say clearly applies when one's dealing with something as important as deprivation of citizenship. And then the quote from the UKI Kingsway case, again relying in turn on the Sun Alliance case, which my learned friend took you to. That is, we say, the meaning of giving notice. And I don't think it was disputed by my learned friend, is that that is what giving notice means as a general matter, can be complied with only by causing notice to be actually received. But what she said is, but section 41, if it simply said giving notice, she, I think, accepted notice to file would not be permitted, because I think she accepted that that is a correct interpretation of what giving notice is. But she said section 41(1)(e) allows the Secretary of State to make regulations. But you have my submissions on that. It cannot allow her to make regulations except for the giving of notice as required by the statutes. If one is then reading what one starts with section 45 as to what does giving notice means, this has been repeatedly held in the authorities to be what giving notice means if you simply have that requirement. Of course, you can add other deeming provisions in a statute that say, no, it'll be given when it's sent, etc. But if you simply have, that's the point being made in Kingsway quoting Lord Salmon, has to actually be received. And you can then see, and that's the whole point of the 29, 30, 31, is you need receipt. Of course, you can prove, if the person can prove they didn't receive, this is in answer to my Lord's point, if it is sent to their address, they're likely to need it's a pretty high hurdle to show it wasn't received. But nonetheless, it is receipt of the notice that is what giving notice means. And our submission will be, there is no reason to depart from that. That is the meaning of giving written notice, as far as the authorities are concerned, unless Parliament says that it means something different or allows for some provision to deem something to be noticed when it isn't, and it simply hasn't in this context. And if that is right, that is the kind of purer way of looking at it, then it is even clearer, we say, that what happened here could not be the giving of written notice. And we do say in that regard, it does go back to the sections of AA and Lord Simon's speech in the Stock case that I took you to. The concern is with interpreting the words Parliament has actually used, and I say giving notice, giving written notice is a phrase that has a hinterland's not the right word, but it's something that's been considered by a number of different cases, and no one has suggested it can mean anything other than this. And that's why the Secretary has to say, no, but section 41(1)(e) can somehow give it a different meaning or allow her to do something different. And you have my submission on that. You have to start with section 40(5). So either route, we say, if the court wants to go down that or doesn't accept the simpler route, if one likes, that Mr. Justice Chamberlain took, is saying it can't mean this. So what it does it in fact mean? We say the authority is clear, and this is what it means. And there is no authority, we say, certainly none that's been cited, that suggests it can mean giving written notice can mean anything other than this. So we also say by that route, the strongly arguable route, we say is also another way in which one can get to the same conclusion. In terms of turning now to some of the criticisms that were made of Mr. Justice Chamberlain's reasoning or his decision by the Secretary of State. Many of the ones that appear in her skeleton, I think she relied on it, and I think we've dealt with them in our skeleton, so I wasn't going to go which weren't elaborated on. But just, I think two or three that my learned friend did say a little more about. The first is, it may be easier to pick it up from the skeleton, because my learned friend made a similar point. Her skeleton, page 47. I think she repeated this criticism, it's paragraph 14 and 15. And our submission is that simply isn't a fair criticism of Mr. Justice Chamberlain's reasoning. He didn't purport to apply some general rule about interpreting statutes or statutes of this kind, or require something akin to a principle of legality. What he did was interpreted the particular words in 40(5) and 41(1)(e) of this statute, and reached the conclusions that he did. My learned friend also, or when I think she was asked what's the key part of the reasoning that she disagreed with in Mr. Justice Chamberlain's judgment, is at paragraph 45, which is his comparison with the CTSA, the Counter-Terrorism and Security Act. And it may be helpful just to turn that back up. You have it at tab 7. And you've seen that how the power operates, what it does. It means you can keep someone out of the UK because you consider them to be a threat to national security. It also, section 4, you were taken to 4.1, which was the notice provision. But you also see 4.9, a person's passport can also be invalidated. And then you have the section 13 provision, and critically section 13.2. And our submission is that Mr. Justice Chamberlain's analysis of this in paragraph 45 ought to be uncontroversial, in that all he was saying there was that Parliament can make regulations allowing for irrebuttable presumptions to be created, and that is what 13.2 is. It is, our submission is, if you allow notice to be deemed to be given, what you are saying is you can make regulations whereby notice will not be given, but can be treated as being given. We say that is the ordinary understanding of section 13.2, which is why you then end up with, over the page is the service of notice provisions. You end up with one fairly similar, 3.2, to the one that we have here, but the critical difference is this is something that Parliament has dealt with and has expressly said in relation to giving notice regulations, well, you can have deeming provisions, and deeming provisions are then made. And again, it is simply a correct observation that the 1981 Act does not include anything of that sort. That then takes us back to what is the correct interpretation of the 1981 Act, 45, read with 41(1)(e). And we would also respectfully say it's not especially surprising that Parliament may well have legislated differently in the 1981 Act from the 2015 Act, because firstly, you'll see the notice provision in the CTSA, the 2015 Act, is of a quite different order It's notice after you make the decision. It's nothing like the same. It's not the requirement. It's not the requirement to give written notice. It's not the requirement to provide certain documents, and it's certainly not something that is a condition precedent to making the order. And it's also not surprising, we would say, that terrorism exclusion orders are treated differently, because while, again, it is a serious impact, taking away someone's passport and not letting someone return to the UK, it is nothing like the impact of permanent removal of citizenship. So it's not surprising that Parliament may well have had, and has had, does have different notice provisions in both. And it also means, it's going back to some of the policy concerns, what position does this leave the Secretary of State in if she can't, if it's not reasonably practical to give someone notice under the 1981 Act? We say, again, no doubt one of the arguments that can be had in Parliament will be, well, yes, but you've got another Act which allows you to take away, invalidate someone's passport, keep them out of the UK, where you don't need to give written notice. You can have notice deemed. If that may be a sensible policy balance. Again, that's all a matter for Parliament. But certainly one can see how the regimes work together with a notice one and one where notice can be deemed to be given. So our submission is there's certainly no error in the analysis in paragraph 45, noting that section 13.2 does not appear in section 41. And the Secretary of State's argument would have to be that if you read section 13.1, section 2 of the CTSA with section 4, it means exactly the same thing as 41.1c read with section 45 of the 1981 Act. Her argument is that those two statutory provisions are doing the same thing.
So the analogue is section 4 of the 2015 Act read with section 13, but if you in your mind rubbed out subsection 2, isn't that right? You'd have so what you'd have is a requirement to give notice, and then you'd have a statutory provision that the Secretary of State can make regulations about the giving of notice. And you say that's as far as section 40, subsection 5, read with section 41 go. That's it.
Correct, my lady. Though even then, if we were having an argument about this, we would still say 40 brackets 5 is still quite different to 4. It makes notice much more important, and even 13.1 is not.
You say that the section 40 and 41 are interfering with a much more fundamental act. They're doing something much bigger, and yet you don't find a provision in the statute that says you can. In the statute, it says you can deem notice.
Yeah, and our submission, no doubt that is because you are doing something bigger, and notice is much more important under section 45. So you would read section 4 next to 45 and say notice is clearly more important on any analysis under section 45. You would then read 13 next to 41.1e, and you would see that 41.1e requires regulations for the requirement to give etc. But on the Secretary of State's analysis, they both mean exactly the same thing, because she says what she's doing under 13 here, she says she can do exactly the same thing under 41.1e. And we said that can't be right. If you put these stats, Parliament must have meant something different by using such a completely different formulation. And we say you can see why, if you just look at the language. What it's doing in 13.2, quite different to what it's doing in 45 and 41.1e. Final point, if I may, subject just turning round, which is deal with, and it's a point I've already to some extent made, but just want to see take the court to the paragraph where Mr. Justice Chamberlain deals with is the consequences, the consequence concern, and where it feeds back into statutory interpretation is, can Parliament have intended that if it's not reasonably practicable, you simply can't remove citizenship? Can Parliament have intended that? That's the argument. It's dealt with at paragraph 50 by the learned judge. And as I'd indicate, he says towards the end of the paragraph, no doubt arguments in favour of amending the statute scheme so as to permit the making of an order without giving notice in a case where that's not reasonably practicable to do so. But he also further up explains why it's certainly not an absurd outcome or something Parliament could not have intended, that is not something that the Secretary of State is able to do. As he notes, statute scheme was not unworkable before that. Certainly there was no evidence that there were any difficulties caused between 2003 and 2018 by the statute scheme not allowing notice to file. And if the argument is, well, Parliament, it is so blindingly obvious Parliament must have intended to allow it, it does seem odd that the Secretary of State herself didn't understand what she was allowed to do between 2003 and 2018 in that way. But then perhaps more importantly is the next observation, is to deprive a person of her citizenship is a very substantial interference with her rights. Cases cited above show. It is perfectly coherent for a statute scheme to provide that an order having that effect can only be made only after causing no decision to be received by the person, at least after taking reasonable steps to bring the decision to her attention. And our submission is, we first endorse what is said further down. That is a matter for Parliament. They can have the argument both ways. They are currently considering this measure, and no doubt all of the arguments that could be made policy-wise will be made. But if one is concerned with the current, how one then interprets the current legislation, if one then goes back to section 40(5) and 41(1)(e), we say the ordinary reading of those provisions is must give notice before depriving, and one can entirely see why that is something Parliament will have decided and not made provisions for dispensing with notice when not reasonably practical because of what is so fundamental at stake here. And if regulations are going to remove that right, which is quite clear we say from section 45, the enabling power, and this is principle of legality, would need to be much, much clearer. It is a very general 41(1) is a very general power. You couldn't possibly say that gives an ability to remove a right that Parliament has conferred to be given notice. And of course 41(1)(e), which is in fact the provision that's used, makes quite clear that what's allowed is regulations for the giving of notice as required by the statute. So our submission is that is what the legislation currently says. What it should say is something that Parliament is currently grappling with. Manuel's Mary, unless I can assist further.
Thank you very much. Ms. Gianovetti.
Just a few points in response. I don't think it will take me very long.
I think you could take your mask off.
It might be more audible. I was saying just a few points to make in response, and I don't think they're going to take very long. What's central to Malone and Friends' submissions, and indeed to the judgment below, is the proposition that a regulation permitting service to file doesn't actually make provision for how notice is to be given. It removes the right to notice. We say that's wrong. The flaw is to read the requirement to give notice in section 40, subsection 5 in isolation, when in fact this is a statute which provides for a power to make regulations, and in context, what section 45 requires is the giving of notice in accordance with the regulations or with general principles. Unless those regulations are unreasonable or inconsistent with the statutory purpose. But you need something like that to demonstrate that the regulations are ultra vires. It's not sufficient to demonstrate that they're inconsistent with what the position would be absent regulations. The attempt to distinguish the Counter-Terrorism Security Act 2015 simply doesn't work. That's also a statute which requires notice to be given. And indeed, the provisions are quite detailed, and the notice has got to include an explanation of the procedure for making an application under Section 6 for a permit to return. That's 4.2. Now, on the learned friend's analysis, and indeed the judge's analysis, the enabling provision in Section 13 of the 2015 Act would also be insufficient to give a power to provide for service to file, because that also gives the power to make regulations about the giving of notice. It's not a power to dispense with the giving of notice. And indeed, that would be the same under the 1971 Act, as considered in Alam, and as to Alam, if we could just go to it very briefly, it's at tab 20 of the authorities bundle. We start at page 230. My learned friend took you to paragraph 4, which is not materially different. Again, the power to curtail leave to remain shall be exercised by notice in writing. The regulations made under the 1971 Act included again a provision for service to file, and that's deemed to be good notice, just as with the 1981 Act. And you have that on page 232. The relevant regulations are set out in paragraph 9, and it's 9.4, which is the relevant one, where attempts to give notice in accordance with paragraphs 2 and 3 are not possible or have failed. When the decision maker records the reasons for this and places the notice on file, the notice shall be deemed to have been given. Now, the learned friends asked you to read quite a big chunk of the judgment. I'd ask you to read the chunk that goes before that. Starting with paragraph 11. But this wasn't a case where the provisions for service to file had been used or relied upon. The court was dealing with the the provisions for giving notice by hand, by fax, by post, etc. And you see that at paragraph 13. And what the court said this, it's possible that paragraphs 1 to 3 of Article 8ZA, that's provisions for service in the ordinary ways, were intended to be treated as operating in the way described by Lord Salmon. And that's summarised in the previous paragraphs. And essentially, it's where regulations say you may do something. That means that it's good enough if you do it, so that's sufficient. So to treat them would be to create a deemed or presumptive giving of notice where the prescribed method is followed. I do not think, however, that this can be correct as a matter of interpretation of Article 8ZA on its own. That's not just because it's difficult to treat paragraphs 1 to 3 as implicitly deeming receipt, when deemed receipt is dealt with explicitly by paragraph 4. Quite apart from that, methods of service provided for in subparagraphs B, E and F are not specific as to the fax number, etc. And then, if we pick it up 5 lines up from the bottom, yet if this is a deeming provision, the fact that the document had never in fact been delivered would be irrelevant. So I'd ask you to read all of the following paragraphs. I'm so sorry, but I'm not going to take time to try and read them out loud to you now, even if my voice would permit me. But you see from paragraph 20 that the issue which really divided the parties on this appeal was what amounts to the giving of notice. That was what amounts to the giving of notice outside the deeming provisions. That's what the case was about. So, my learned friend and indeed Mr. Justice Chamberlain were quite right to say that there's no case saying that service to file is sufficient. That's a slightly tendentious way of putting it, because there's no case saying it's insufficient either. There are provisions in numerous statutes, and there is no authority either way. But certainly Alain proceeded on the basis that that was the effect of the deeming provisions. But I don't rely on it heavily because it wasn't on point. It was sort of observations made en route to what the court was really considering, which is what is good service when you're outside the terms of a deeming provision. I think that's all I need to say, all I can usefully say in response. I don't think I can assist any further. I think one point I should clarify, and my own friend was very careful in the way he put it, and he didn't say that we conceded that service was a condition precedent. It's common ground, we can't advance the argument here, and that's essentially because we didn't get permission to argue it because it wasn't advanced below. I'll give you a long explanation as to how that came about, which I won't. But I'd just like it to be quite clear so it doesn't appear in the judgment that the Secretary of State concedes that this is a condition precedent. It's simply not something that's open to us to argue here. Unless I can assist on anything further, I think those were my submissions in reply.
Well, thank you. Thank you both. We will take time to consider our judgments in this important case and deliver them in the usual way. We ask for typographical but not other corrections, and we ask you to agree consequential orders and costs and so on. And if you can't agree them, we'll deal with those matters in writing.
I'm sure we'll be able to approach it cooperatively.
Thank you.
Thank you.